Hey guys, Toby Mathis here with Anderson Business Advisors. And today we're going to be talking about how to keep your assets safe from lawyers, snoops, and Uncle Sam. Those are the big ones. Before we jump into that, I really want to take a 10,000 foot view of what asset protection is and what it isn't. Asset protection to me is more than just picking your favorite flavor of asset protection. For example, a domestic asset protection trust, and that's the key you play on the keyboard. Everything's a domestic asset protection trust. Or let's say you love LLCs, an LLC, and you're trying to get an LLC to do something that it wasn't designed to do, or you're trying to get a domestic asset protection trust to do something it wasn't designed to do. At the end of the day, we like to play chords and use the appropriate entity for the appropriate type of asset. And more importantly, we apply it to your circumstance. For example, say you're in Texas and you own your house outright, and some asset protection attorney says some creditor is going to come and try to take that away from you. We've got to put it in a trust, and we got to put an LLC as the beneficiary. We got to do all this stuff. Hold on for a second. Time out. You live in the house. Texas is an unlimited homestead exclusion state. Like, that's not why you'd be doing that. You might be doing something along the lines of maybe a trust for estate planning. Maybe you're doing it to create a legacy. Maybe you're doing it to get your name off of it. But the last thing you need to be worried about is the equity of that property. And what you don't want to do is undo the protections that are already there. So whenever somebody's looking at asset protection, it can't be this one size fits all, because it doesn't work. What does work is facts and circumstances and using the right tool to get the job done. So let's take a really far back look and let's talk about what actually works in asset protection. So I've had tens of thousands of clients all over the country. We've been in litigation where there's been upwards of close to $100 million, actually $96 million of judgments. There's been cases where we were able to thwart large pursuits where we got it down to almost zero. And the best ones are the ones that never even occurred because nobody knew the assets existed. And I've come to believe that that's the best route to go. It's great to have a protection plan that's going to work under pressure. It should, but let's avoid the pressure if we can. And I call that security through obscurity. So I'm going to make that a main point. It's called security. We'll just put a misspelled through. Obscurity. In other words, if they can't see it, they can't take it. We want to make sure that, hey, if somebody comes sniffing around your stuff and they don't know that you've got 20 properties, the chances are they're not going to pursue it because a lawyer has to look at it and say, not only do you have a valid claim, but I need to be able to collect. In other words, the last thing you want is to have a client that retains you, you're on a contingency fee, and you go sue somebody and you get a judgment and you've spent $200,000 in costs and time in getting that judgment and you can't collect on it. You may as well not even take that case. And most attorneys won't. Flip it around. If it's 100% certain that there's going to be a collection, all of a sudden, not so good claims become valid claims because those two things interact. So the easiest way is don't have valid claims against you. That's a great one. And number two is if there is a valid claim, make sure that the odds of collection are decreased so that you can settle and get on with your life. That's why we have insurance. I'm always going to tell people, have regular insurance, have umbrella insurance. That's lawyer insurance. If it goes above that, that's what your asset protection plan is there to protect you from. But that's a huge one. And so I always say, like, obscurity and using the ability to keep your name off a public record is a huge one. And here's why it's important. Whenever we have an asset protection plan, we have inside liability, things that occur inside of an entity. So for example, let's say I own a piece of rental property and a tenant falls down the stairs and that rental property is inside, let's say this is an LLC. The liability is going to stay inside that entity. It's not going to be from the outside. It's coming from inside. On the flip side, we have us out here. Woo! And sometimes we do things that cause liability. For example, if you have kids, maybe they get into a car accident. We get at least, like I've had a lot of these, I shouldn't say at least every year, but we've had quite a few where somebody's kids go to college or something and that kid gets into a car accident and either hurts somebody or in a couple of cases kills somebody, right? You have a young person with just unfettered claims, and guess who they're coming after? Not just that individual, but also the parents. So that's outside liability. And there's nothing we can do about it. This is outside liability, like we have a broken picker, right? You know what a broken picker is? When you pick the wrong spouse and you end up in a divorce, right? So maybe you have a divorce and they're looking at you. We need a plan that's going to work in the event anything happens. Do you know that there's entities that actually they can't be even pierced for child support or for alimony? And I hate to say child support because that sounds so horrible, but they do exist, and it needs to be used in the right circumstance. Sorry, but they're out there. Actually, only one state has it, and I happen to be standing at it. I'm in Las Vegas, but Nevada does have that protection if that is something that's a serious concern for you. For example, let's say you're somebody who has a lot of assets. Maybe you're older and you're marrying someone who maybe younger and doesn't. You may want to consider, hey, do I want to put something in here, especially if you have kids, to make sure that it never becomes an issue. It never becomes an Anna Nicole Smith, if you're familiar with that case. A gentleman late in life marries a Playboy model who's 28. The kids got disinherited because he predeceased. They ended up prevailing in court, but boy, it was years of turmoil and a lot of uncertainty and a lot of anger and frustration, and it didn't do anybody any good. At the end of the day, if we want to try to avoid some of the stuff from the outside, we need to have the right tool. So I use something called the Trilogy. I always look at it and say, all right, the Trilogy is the state, courts or third parties, and the feds. So whenever we're dealing with stuff, we always say, like, hey, I can create an entity in a state. So there's 50 states, 50 flavors. I could create a trust. I could create an LLC. I could create a corporation. I could create a version of any of those. Like, for example, LLCs may have series LLCs. Trusts, there's revocable, there's irrevocable, there's asset protection trust, there's statutory trust. And I just go down the list. An LLC, for example, I set it up with the state, but over here, the feds don't have a tax form for an LLC. In fact, they don't even know what it is. You have to tell them it's taxed as a corporation. It's taxed as a partnership. Ignore the LLC. Tax it as an S corp. The feds, this is how we're paying our tax. The courts, that's your paperwork. So if I am in a state, for example, that says nobody can take away the interest of a member of an LLC, nobody can foreclose on those interests, and then I put in my documents, any creditor can become a member by bringing up a claim in a court of jurisdiction, and they go after that, I undid what the state statute says. Or if I have a state that doesn't require distributions, and hey, I'm going to do an asset protection plan. I'm going to put myself in Wyoming. I read about Wyoming and Nevada, and these things are really great. And I put myself in Wyoming, and somebody comes after me for something else, and they get a lien against my LLC because that's the only thing they can get. But then my LLC document says, hey, you have to distribute any revenues and, on an annual basis. You just undid it. All three things need to match up with what you are trying to accomplish. Now I'm going to go all the way back up to here. You heard me say that there's security through obscurity. And so here's how it works. There are states that do not list you on the Secretary of State database, or whatever it is in that particular state. It does not list you as a member, or does not list you as a manager or a director or in any position. There are states that are completely devoid of listings. It means there's nobody in that Secretary of State except perhaps a representative of the company. It might be a registered agent and the incorporator. For example, in Wyoming, that's what it is. There's nobody else listed. Other states, they'll have all the members. Hey, anybody who's a member needs to be listed, or the manager needs to be listed, or all the officers and directors need to be listed. In some states, the officers and directors have to be listed, but only for that moment in time, meaning that you could have an attorney like me who goes in and is a nominee in all those, and you're not under a duty to update it. So the attorney can withdraw, can put in there. I always put nominee, like in the state of Nevada, I always put nominee. And then I immediately resign and hand over that control to the client. Nobody can see the client is in the Secretary of State's database. Now, before everybody goes and screams and says, oh my gosh, money laundering and all this stuff can happen. I read about this in the Panama Papers. No, nobody needs to know whether you own interest in a company. That's not what it's about. Right? Hey, Toby, do you own an LLC? I have hundreds of properties. I don't want everybody to know. I'll keep that private to myself. I don't need to know. Like, it's okay that you know I have them, but I certainly don't want anybody to go out and find it. If somebody was trying to do bad by me, like, hey, I'm going to target you. I'm going to go talk to all your tenants, and I'm really going to make your life hard. Some nasty old lawyer out there. I don't want them to be able to reverse engineer. I want it to be very, very difficult. Now, that's very different than concealing ownership, because you don't conceal ownership. If you're going to have a bank account with these guys in that third party, it says courts and third parties, banks fit into that category. Banks have to know who their clients are. They're going to ask for the documents. They're going to ask who's a beneficiary under this thing, who's getting a benefit out of this entity. They're going to ask that because they have a legal requirement to know who their customers are, to prevent skullduggery and bad stuff. I'm always shocked when I hear politicians, especially, they start screaming around, oh, we need to have transparency. Why? I don't think it's anybody's business what I own. I don't think it's any business. Like, you don't get to go pull my tax returns. This guy over here can't go pull up my tax returns. But I want to know what you make. No, you don't get to know that information. We don't walk around with that information available to the public. Public record over here is completely different than the appropriate parties knowing who's in charge of the entity for licensing purposes, for banking purposes, filing of taxes. But those aren't public records. All three of those things are private to you. And that's a huge one. Huge one. Now let's think of this. Also aligned with that, if you have somebody who is getting your tax return. So for example, you have somebody that you were in a domestic partnership, or you were in a marriage or something, and somebody's coming back after you for increased alimony. If you have something else out here that is filing its own tax return, whether it be a charity, whether it be a C Corp, whether it be a trust, that's an irrevocable trust, filing its own taxes, and it is not going under your return, guess what they cannot figure out from looking at your tax return? They're not going to be able to figure out what is in those entities, whether those entities exist. If they are able to see them, they don't know what they're worth. It becomes much more difficult, and you're not constantly triggering, boom, 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 I'm triggering another adjustment, or somebody's coming after me. Now, I've had clients live through horror stories where every year they had to go deal with that. That's where you start putting those layers. That's why I say it's facts and circumstances. Is it right for you? Probably not. Unless you're in a nasty situation or you're concerned about one occurring, then maybe we put some of those things in place. For 99% of you, no. We don't need to go that deep. We don't want to. What I like to look at is we have 50 states, we have 50 different menus. We like to look and say, all right, what type of activity is it? Like, for example, if it's real estate, that's going to be an in-state LLC most of the time. There are going to be exceptions, like maybe Florida, maybe California, where they have a high franchise tax. Florida, because you can have a land trust that accomplishes that same thing without doc stamps and without incurring that extra tax. Maybe we're looking at Tennessee, for example. Tennessee, you have the fonts exclusion. We need to be very careful. We're probably going to use a series LLC in those circumstances. There's very specific issues depending on the state. And then we look at you and we say, guess what? I can separate this, and I can actually put something, a nice little wall right here, what we oftentimes call a holding entity. So I'll just put hold, if you can read that, a holding entity. That holding entity is great because it keeps people from getting back to this particular entity. So for example, if somebody comes after John Smith, the client. And John Smith is a member in a Wyoming LLC with John Smith's spouse, for example, or maybe it's their living trust having the holding entity because they put together a really good estate plan. But let's say that they're coming after it. The most they would ever get here is a charging order. That's the sole and exclusive remedy. They can't foreclose on it. They're not going to get through it. That's fantastic. That keeps them from getting to this next point. And that's what we want. We want to keep them from hopping on over and getting there. Anyway, so that is some ideas for how you keep away from lawyers, snoops, Uncle Sam, how we can keep our matters private, how we can use the power of different entities for benefit. I didn't jump a huge amount into the tax side. We will do that soon, depending on the type of asset you have. So we'll be looking at real estate. We'll be looking at securities because those are the two big ones right now with inflation running up. But this gives you a pretty good idea of how you too can have security through obscurity.